who will be the focus of our webinar this morning, Miranda Lam and Alex Cox, both from McCarthy Tetrault law firm. And Miranda and Alex will introduce themselves as we move a little bit further. But first, I'd like to welcome everyone for joining us this morning. We've got lots of great questions that have come through, and we've got some expertise right here in your home office, wherever you are in BC. But thank you for joining us. Again, my name's Dawn, and I'm a business advisor with Women's Enterprise Centre. We're going to be recording today's sessions, so you will have access to this information. Also, after today's session, you will receive an email. Anyone who's registered will receive an email with the information that's covered today, with some great links that have been provided by McCarthy Tetrault, some information about resources that are available, any of the links of that Women's Enterprise Centre has also prepared. So we've got good information for follow-up as well. Okay. And our next slide. So an opportunity for you to engage in this process this morning. We want more of your questions. We'll be starting with some that we've already received, but as we go along, if you have a question, Carrie Lee, in our Skills Development Manager, will be taking care of reading out those questions and managing that from the background. So you can see here, right on the bottom, there's a chat box on your Zoom. Just click on that and you can ask a question to a particular panelist or to all presenters. So please do participate with that chat. Okay. And here are our panelists, and we are so thankful to have Miranda and Alex with us today. Just a big shout out to both of you for joining us and generously donating your time to answer the questions. We've had so many. These are challenging times for small business, but we know that women entrepreneurs are strong and resilient, and to be able to have this expertise is phenomenal. So thank you, Miranda and Alex. We really can't thank you enough.
It's our pleasure. Thanks for having us, and hello to everybody out there.
Thank you.
Okay, so today we're just going to touch on services and programs for those of you who are not familiar with Women's Enterprise Centre. And then we're going to turn it over to our panelists and then participate in a back and forth, your opportunity to ask questions, to make comments, to get more information. And at the very end, we'll find out how else we can help and what else is coming up. So that's our plan. Today we've got an hour. Let's get started. So about Women's Enterprise Centre, we are a not-for-profit organization serving all of British Columbia. We help women entrepreneurs to realize their business potential. We do that through a loans program, business loans up to $150,000. We provide professional advice and resources, skills training such as these webinars and lots of training resources. We provide mentoring programs, and most of all, and especially right now, a supportive community. That is a part of our mandate, and it's an important part in difficult times. There is no denying that this pandemic has caused challenges and upsets in business, and lots of questions and lots of need for resources and lots of need for support. And that is a role that we're proud to be able to play throughout the province of BC. So thank you for joining us. Specifically during this time, Women's Enterprise Centre has provided interest relief for 3 months for our loans clients, many of whom have been able to participate in that, as well as deferral for 3 months of loan payments. And many of our clients have been able to participate in that. We've also put most of our webinars available free of charge during this time. And our financial fitness webinars, we have made those available. Those recorded webinars are now available. Now is the time to be financially fit. So you want to access those resources, and our website has a specific COVID-19 resources to help you. Here's where you will find it. Thank you, Carrie Lee, for this slide as well, right on the website. So we're keeping that updated with good information and setting out these resources specifically at this time for you. So please do access our website for upcoming and current information. Okay. So tips and resources, we've got really some pieces that all of this is detailed in a previous webinar, so I'm only going to touch on them. We really are strength in numbers when we come together and support one another, but we want to give you these key messages during this time. Focus on what you can control, not the things that you cannot control. The Canadian dollar, you cannot control what businesses are forced to be closed, but you can control other things, and focus on those. Follow public health authorities. Make sure you're getting good information. Manage your cash flow. And there's lots and lots of things that Women's Enterprise Center has prepared for you to help you to manage your cash flow. Practice your negotiation skills. Now is the time to be negotiating. Look at where you can negotiate and practice those things. Build resilience. Be innovative. We've wonderful examples out there of businesses who have been able to pivot, sometimes just a small pivot, to make a difference during these difficult times. And most importantly, create an action plan. Prepare what it is that you can do to make your business stronger tomorrow. Strength in numbers. We're here. Check our website, and you can download the previous webinars that we have done that elaborates on all of those key points and key messages. Okay. I am going to turn it over to this session to our panelists today, Miranda Lam and Alex Cox. Welcome to both of you. We're going to start off with having you introduce yourselves, and then Alex is going to lead in with talking about leasing.
Sure. Why don't I kick it off, since Alex can carry the mic, or the screen, if you will, for the balance of the conversation on particularly leasing. Like I said, good morning, everybody. It's nice to join all of you and be in support of Women's Enterprise Center and all the good, terrific work that they do. Normally we maybe do this in person or have more interaction. So at this point, all you are is just staring at us. If you have any questions or want to interject while we're talking, please do. It'll make it a little more lively and a little more engaging. Alex and I are both partners in our litigation group in Vancouver. We've been handling and managing a number of questions lately, all flowing from the COVID-19 circumstances. So today our hope is just to share with you a few of the things that we've been hearing, some very commonly asked questions, as well as hopefully give you some general guidance on things that we're hearing, and try and answer your questions as best as we can. I'm obliged to say that we can't give you all individual legal advice right now, but we're certainly very happy to provide some general guidance, and happy to talk more with all of you as need be. So With that, maybe I'll turn it over to Alex first and let her kick off the substantive discussion.
Thanks, Miranda. Good morning, everybody. As Miranda mentioned, we're both litigators in the commercial space, and one of the things that we do is provide advice before disputes arise so that parties can avoid those disputes and hopefully not have to go to court. And so one of the topics that's been coming up a lot in this since the pandemic has arisen is the greater stress in the commercial relationship between landlords and tenants. And in the commercial space, but also residential. And I'm just going to focus my comments on the commercial space today so that you have some general information about your rights and obligations and some tips about how to get ready and be organized and proactive. So first of all, nothing yet in BC has been legislated in respect of exempting parties from their contractual obligations in the landlord and tenant relationship. There have been changes legislated for residential tenancy arrangements, including a moratorium on a temporary moratorium on evictions, but so far nothing for commercial tenancies. Yesterday, however, there was an announcement by the federal government of a commercial rent assistance program. I don't know if some of you may have seen it. It was announced by the Prime Minister. There are very few details at the moment. I've tried my best to find out more information about it, but so far we know this. They're going to make some money available together with the provinces to assist with lease payments for commercial tenancies for the months of April, May, and June. That will be rolling out soon, and we hope to see the details and how that's going to work. And so stay tuned. So what can you do to be organized? I'm just going to give you a few tips about getting organized and talk generally about the biggest issue for commercial tenancies in light of the pandemic, which is what happens in the case of non-payment of rent. I mean, there are many different aspects of a commercial tenancy relationship, but that seems to be the biggest one and the one that we're seeing that we're getting most inquiries about. And then some practical advice about just some things that you might want to consider doing to negotiate and find a solution together if you're a landlord or if you are a tenant, so that the relationship can continue. So first, what can you do to get organized? Gather the documents, read the lease, dust it off. If you don't have it, pull it out. Make sure, in many cases, the lease isn't the only document governing the relationship. There may be an amending agreement or an addendum, and you may have forgotten about that and it may be tucked away. So just dust that off, bring it out and give it a read through to see if you have everything that the lease refers to, all of those documents, just so that you know you have it and you have a general idea about what it says. If you have specific questions about how to interpret the lease, that's where we suggest you seek legal advice about that if you have a question. And then once you have those documents organized, at least you have a handle on the universe of relevant documents. So that what happens in the non-payment of rent scenario, I'm just going to give some general guidance of what can or cannot happen so that we can talk about how to avoid that. The first issue generally is if you're not able to pay rent or you haven't paid rent as a tenant, is it a default? And that's a scary word, but it's usually something that's covered in the lease. And you should read the lease because it will say whether or not non-payment of rent is a default. I think a lot of people assume right away that if they don't pay, you're automatically in default and something terrible and awful will happen immediately. But generally, the lease will describe whether non-payment is a default and whether that happens right away, or whether certain things have to happen first. For example, there may be a requirement for notice to be provided by the landlord to the tenant, notifying them that they are in default. And that's generally the case. So it won't be a mystery. You will, if you're a tenant, the notice will be given, noting whether you're in default. And both parties should be checking the lease to confirm whether that is the case. Generally, there's a cure period in the lease, which means there is a time between when the tenant is noted in default. There's a time to remedy that. It can be 14 days, 30 days. It depends on the lease. So you should check to see what the cure period is. And that means that you have time before anything else happens to resolve the issue and pay the rent if that's the case, before anything can become escalated. In BC, there isn't a minimum statutory requirement like there is in other provinces of a minimum amount of time for a cure period. So again, that's one of those things that it's lease specific. If the cure period expires and the non-payment of rent issue has not been resolved, then generally landlords have two options available to them. They can affirm the lease, which means they keep it alive, they want to keep it going, and they can pursue rights and remedies, or they can decide to take action and terminate the lease. In both cases, generally the lease will require some notice provision be provided to the tenant so that everybody knows what's going on, and particularly in the case of a termination, there will be some notice required so that you understand what's going on, and the notice may even explain when that is going to happen. And landlords have different rights and options available to them. If they terminate, one of those is the right of re-entry or repossession. But in BC, there's actually a very higher requirement than in other provinces. Unless the lease specifically provides for the right of landlords to re-enter the premises on termination, then landlords have to apply to court and get a court order for that. So that's another process that has to go through, and the parties, the tenant will get notice of that court hearing and have the ability to participate in that. There are other rights and remedies that landlords have available to them. I'm not going to go through them in detail, but this is sort of this is a general information on what could happen if payment of rent isn't paid and it isn't cured within the cure period. So how do we avoid all the worst case scenario? The advice that we've been giving to both parties, landlords and tenants, is this is the time to think about and discuss a negotiated solution, some alternative. It's in both parties' interests generally to keep the relationship going. Not always, but generally. So some options available and that we've been advising both parties are to consider a deferment agreement where there's an agreement between the landlord and tenant to defer rent for a certain amount of time, or an abatement agreement, which is where you don't have to pay rent for a certain amount of time. Some other negotiated solution where the landlord might accept partial payment right now and give credit or not agree not to go after arrears, or a surrender of the lease. And a surrender of the lease is where both parties are clearly aware that the leasing relationship will be over, and the tenant is giving up the right to be in the premises, and the landlord is then agreeing to terminate the lease. And in all of those different situations, it's a very, very good idea to get it down in writing, get the agreement in writing so that everybody knows what the rules of the road are, what your rights and obligations are, and how that's going to affect the underlying lease terms, what changes are going to be made to that. Some other things to think about, just be cautious about communications if you're the landlord or the tenant that suggest that you will not be abiding by the terms of the agreement. For example, if you're a tenant and your rent is due on the 15th of the month, and on the 12th you indicate to the landlord, I'm not paying rent, I don't intend on paying rent, I'm never going to pay rent. It's potentially an argument for the other party to say that you have that's an anticipatory repudiation of the agreement. That's a mouthful, but what it means is that the other party says, well, you've told me you don't intend to abide by the terms of the contract, and therefore I can accept that as you saying the agreement is over, or accept that as a breach of the agreement and then enforce their rights and remedies. So just be careful about that in your communications, in your leasing arrangement. Something else to be aware of is I expect if matters are not able to be resolved and there are court processes that ensue, one remedy available to tenants it's an equitable remedy. It's called relief from forfeiture. And that's something that I think we will see a lot in court processes if they do go ahead, where the tenant can say, yes, I may have breached the agreement and I didn't pay, but I'm pleading to the court to be relieved from forfeiting the lease. And there are a bunch of requirements and there's a test that you have to meet for this, but it's just something to be aware of. We're advising both parties, landlords and tenants, that this is a real possibility, and courts are likely to be sympathetic in these circumstances, these difficult circumstances. Our courts are technically closed for general business right now, but there are procedures available for emergency applications, and I expect that landlord and tenant disputes, especially with respect to termination or re-entry, will be considered, likely to be considered, one of the emergency applications that they will hear. But everything is a little uncertain and there will not be immediate access to the courts in the ways that there used to be before that. So with that, I'm happy to turn it over to Miranda for discussion, unless there are any, I see there are chats, questions.
So Carrie Lee is managing all questions that are coming in, and this might be an opportunity for a short Q&A, but Alex, thank you. You know, this is good practical advice for our participants today. You know, gather your documents, understand the language and the differences in your contract, to look for a negotiated solution, and then understand processes if those are not working. So it's a great practical tips, Alex. Thank you.
One additional point, and I'm sure it's obvious to many people, but before disputes arise or when disputes are starting to brew, both parties can be, it can be emotional, it can be very stressful, but in this situation, it's sort of, everything is amplified and both parties are going through a stressful time. So just keep that in mind with any communication that you're having with the other party to a contract. Both parties are likely feeling some stress right now. So just to keep that in mind.
And you also said, that it's in both parties' interests for this to work. Everybody wants it to work.
Absolutely.
Mm-hmm.
I do have a couple of questions here, if I can pop in. So one question that was submitted is, I have a very adversarial relationship with my landlord. I don't want to even try to negotiate rent payments. Where do I start if I can't make those payments?
Right. So the other advice we've received, I've received inquiries like this already from both sides before about sort of the history. This is a long and sort of tortured relationship, but we're encouraging parties to not think about the past right now and focus on the present with a new lens and an understanding that, you know, we're all in this together, that both sides are, that all parties involved are likely undergoing some stress, and to focus on what they can do going forward without the history in mind. And so I encourage you to approach it with that mindset, and hopefully the other side will too, and to do it, to approach the other side despite the tumultuous past that they're making.
Great. Another question that's coming in is, you know, some good news. Somebody had the April rent. The landlord said, no, you don't have to pay that. You don't have to pay May. Not sure about June. But when you talk about getting it in writing, does that need to be a full-on amendment to the lease or an agreement, or is an email okay? What's your advice there as far as if you're working out and negotiating these new terms, what should that in writing document look like?
I mean, a formal signed written agreement is always the highest level of assurance, but these times are challenging and there are a lot of moving parts. So if you get something in an email is writing, and an email can be good enough to be evidence of the parties' agreement. I suggest asking for a formal written agreement if you have any questions about it, or you're not sure how it might impact the underlying lease arrangement. You can always ask the landlord for that. But an email is good, and we've been advising both parties, at the very least, put it in an email.
Okay, great. And then one question from the chat before we move on to Miranda. I have a participant that says, I sold my retail business on March 30th, and the new buyer was supposed to sign a new lease with the landlord and waived this subject. There might be a word missing there. However, she did not sign the lease and has now moved out all of the stock and fixtures. Now I'm left with an empty space and no stock and a lease payment for the next 18 months. What are your suggestions?
So the new buyer. So I think it depends on whether I can't tell whether the purchase agreement has gone through or not, or whether I think this is a very fact-dependent situation, and whether or not the purchase agreement has gone through, whether your underlying lease with the landlord is still continuing. I'm sorry, I can't be more helpful than that.
Yes, she's commenting here as we go through, Alexandra, if you have the chat open. She says she waived the subject tossing the lease, and the purchase closed on March 30th. So it looks like the buy and sell was closed, but the lease agreement was never signed. So taking over of the lease, and perhaps Shannon, if you can clarify that. Yes.
And so is the lease still continuing with the landlord? That would, and the landlord will not release. That's a complicated topic, and that will depend on what the terms and conditions of the purchase agreement are with the purchaser. So you'd have to get specific advice about that, I think.
This will probably segue us into Miranda with the other contract topics we want to talk about. And everybody please typing those questions in there, and we'll scroll back and forth as we go through, so as they come up. But Dawn, I'll hand it over to you and Miranda now.
Great, thank you, and thank you for your questions, everyone. These are helpful. And Miranda Lam is here with us to talk about contracts. We had lots of questions related to contracts of all kinds, and questions about what is a force majeure, and does pandemic come under force majeure? So lots of questions and information coming to you now from Miranda. Thank you, Miranda.
Oh, sure. Not a problem at all. And some of this naturally overlaps with lease considerations, since a lease is a contract too, but there's a very specific regime when it comes to leases and enforcing leases. And so Alex will certainly chime in if there's anything else that as we're having this part of the conversation that might be relevant to add as well. Just to pick up on the question about the business, and I think it was in Prince George, I agree with Alex. I think even before you look at your lease, you might want to look back at that purchase and sale agreement. You might have some obligations that you can enforce against the buyer, including hopefully or potentially an obligation to have entered into the lease. I mean, I know that there were subjects waived, but there still might be, for example, an obligation in the contract requiring that buyer to assume the lease obligations. And so if that's the case, then you would have potentially a claim against the buyer, and you can enforce those rights against her. And then you just have to figure out what you need to do in terms of the lease itself to minimize any damages that the landlord might have in terms of a claim against you, which you would then claim against your buyer. So it is very fact specific. We're sorry, without looking at the agreements, we can't give you any more specific guidance, but it sounds like you might have a couple of hooks in terms of something that you can use against, or rights you can enforce against the buyer, and hopefully a way to mitigate your damages to the extent your landlord is going to be coming after you since you're still on the lease for the balance of the lease payments in the lease term. So in terms of contracts, I never thought that contracts would be such a hot topic, because frankly, contracts and reading through them and the fine print is the domain of nerdy lawyers and really no one else. But now these days, contracts have sort of become de rigueur. And one of the things is, as Dawn has just mentioned, is this fancy term, force majeure. So something that I thought might be helpful for all of you out there in cyber world is I might just go through a couple of typical provisions that you might find in your agreements. So to use Alex's phrase, when you do dust those contracts off, because I'm guessing not very many people have read through them or have had the need to go through them in great detail until now, whether it's a contract with a supplier, a lease agreement, a contract with customers, whatever it might be, dust them off and take a look for some of these kinds of provisions. We are getting lots of questions either because you are in the position of wanting to enforce your rights under a contract, or the opposite. You want to get out of that contract because COVID-19 has given rise to a situation where you simply can't perform those obligations any longer. So what are some things to look for? There's a couple of provisions that you could consider. One is, if it's a lending contract, for example, a finance contract, there might be a material adverse change or material adverse effect provision. Usually, spoiler alert, unfortunately, those are written in the favor of, for example, the bank or whoever's lending you the money, and they're saying, and it's the ability for a party to rely on a material adverse change, otherwise known as a MAC clause, and to point to the MAC clause and say, well, there's been a materially adverse change or event like COVID-19, such that I no longer can perform my obligation to you, such that I can no longer lend you the money, or I can no longer carry on with these terms of financing. And so that's a provision to look out for, to see if maybe that gives you a hook to either relieve you from performing obligations, or perhaps gives you some leverage to negotiate a different kind of bargain. So that's one kind of provision. The other kind is, as Dawn was alluding to, is force majeure. Force majeure has sort of seen a resurgence in popularity. I think if you Google it today, something like 62 million hits will come up. But I think, you know, even 2 months ago, few people had probably used the term, certainly in law school. I think that got about 10 minutes in contracts class in first year. Force majeure, though, is a concept that's being tossed around a lot, but I have to be very clear, it's a very specific provision in the contract. So if you don't have that provision in your contract, you can't rely on it. And so some of the questions that we're seeing from clients and other inquiries are things like, well, there's a pandemic, so it must be force majeure. Force majeure without being tied to a specific contract provision isn't a thing. So it isn't a get out of jail free card. It doesn't allow you to escape your obligations under the contract. But if you have that provision, what does it look like? Well, usually it uses the words force majeure, and it contains a couple of elements. It'll have something like, it'll specify triggering events. It'll say something usually like, if there is an event beyond the party's control, if including or things like fire, terrorism, acts of rebellion, acts of God, pandemic. It might actually include the word pandemic. If it has that kind of triggering event language, then you are into a force majeure situation. So the first element is you need a triggering event. The second is that then it has to have some sort of effect or impact. So what is the impact on the parties? So if this triggering event is beyond the control of the parties and is such that you can no longer perform your obligations, then you might be released. But now the third element is, well, what does the release mean? Because sometimes the effect of triggering or relying on your force majeure clause is indeed that the contract is terminated. It's at an end and you don't have to perform your obligations. But in other situations, depending on how the contract is drafted, it could simply be something like the obligations are paused. So just yesterday, I was looking at a contract between a supplier and a vendor. And the vendor was insistent that, well, we have force majeure. It even says pandemic right here. So hooray, the contract is over. But actually, the contract was a pause. All it meant was that the supplier didn't have to provide the goods that it was obligated to provide under the terms of the contract in time, which meant, instead of delivering the widgets every 30 days, there could be a bit of a delay. It didn't mean that suddenly the parties could stop and essentially break up. And so that gave rise to a whole different conversation in terms of, okay, if we're stuck together and we can't actually perform this contract in this way, and the poor supplier who has to deliver these widgets, it's now costing him 10 times what it cost him before. What do we do in terms of trying to live with this contract, keep it alive, and maybe reduce the obligations on both sides? But the vendor certainly thought, because it said pandemic right in the agreement, that meant the contract was over and they could just escape scot-free. So take a look at, if you do a force majeure, what the consequence of that force majeure provision is. The final thing about force majeure that you should note if you have that provision in your agreement is notice. Sometimes these agreements will say, in the event of a pandemic, this is what's going to happen to the obligations. And in order to trigger this clause, you must give notice within 10 days of this act. So, there's a fire. You have to tell the other side within 10 days of that fire, I am triggering this provision. I am not going to be performing these obligations and I'm relying on the force majeure provision. If you don't honor or follow that 10-day notice period, for example, I'm making up the 10 days, it could be 7, it could be 30. If there's a notice obligation in the contract, make sure you follow that, because otherwise that gives the other side the ability to say, well, sorry, you can't rely on it because you didn't give me notice in time. So you just want to make sure you're following exactly what the provision says. So that's if your contract has a force majeure provision. If it doesn't, don't worry. There's still potentially another legal concept that could come in, and it's called frustration of contract. And so frustration of contract exists where the parties simply can't perform the contract anymore. The contract is frustrated because some supervening event has occurred that renders performance impossible. So now that's a pretty high standard. Impossibility is a tough one, but it's it's all about what's within the party's control and whether or not you can still live up to your obligations. That is a common law doctrine. It doesn't have to exist in your contract. It might be something you can still rely on, except that if you are going to rely on the doctrine of frustration, it doesn't allow you to terminate your contract. It means that the contract is terminated, pardon me. But to the extent performance has somehow up until the point of frustration, given rise to some benefit from one party to the other, there's another concept, another $64 million word called restitution that might kick in, meaning that to the extent there has been some benefit to one party over the other, flowing from the performance of the contract and then the frustration, the other side might have the ability to come after the party who received the benefit for some restitution or for some compensation. So that's the common law concept of frustration if you don't have a contractual provision called force majeure existing within your agreements. The other provision I'll point out in a contract that might be worth looking at is, of course, the default and termination provisions. Just to see whether or not the circumstances that have arisen give rise to default and give rise to one party's right to terminate over the other. And there's a couple of follow-on things from that also tie back to force majeure. Maybe you can't terminate, but there's been a default of some kind that either accelerates the payment of obligations or slows down the payment of obligations. Even if you, short of termination, maybe as Alex talked about in the lease context, there's a cure period. So you've got a default, but you have 30 days to figure things out and see if you can cure before there's an event of default. That 30 days is usually an extremely valuable time to just have an honest conversation with the other party and start negotiating. Particularly, as Alex was saying, in the lease context, these days, I think both landlords and tenants are more interested in staying put. When the real estate market was high flying, landlords probably were a little more aggressive because they could go and get a tenant from somewhere else the next day. But these days, people want to try and hold on to their obligations and just make it work. And I would say the same thing in some contractual situations. In the supplier-vendor situation I just described to you, and something that came up yesterday, the reality is people want to try and figure something out and work together. Some of that I think is just commercial goodwill. Some of that is it's hard to find another, in the vendor supplier situation I was just giving you, it might be hard to find another supplier if that contract does come to an end for that particular client, because we're not sure what other comparable suppliers will frankly still be in business, or if their downstream suppliers are going to be in business to provide the appropriate materials for that particular widget. And also a practical consideration, as Alex mentioned, the court's operations are suspended right now. So nobody's going to be able to rush to court tomorrow and enforce their contractual rights quickly. So people are also trying to figure out how they can fix things themselves and not wait for a third party like the courts to intervene, because that could be many months from now. And that's yet another layer of uncertainty that people are hoping to avoid. The final thing I'll say in terms of dusting off your contracts and looking through them is to figure out if there are other points of leverage. And by that, I mean, it might not be obvious. An example I can give is in some ways the dispute resolution provision. So I just talked about people not wanting to rush off to court to enforce their rights because the courts are closed. In some circumstances, that can be a point of leverage, because you know what? You're just going to have to deal with me because your only other option is to go to court, and there's no going there right now. Sometimes that's all it takes to kind of crack the nut open and just have a real negotiation. Your dispute resolution clause might be something like, we're going to arbitrate instead of going to the courts. And there's a 5-step arbitration process that we must take and follow these procedures. That could be more time consuming and more expensive just figuring out the problem. So I say that only to remind everybody to just look through your contract and think about the leverage that might exist in it, what kind of is in your column that you might be able to use, all with a view to actually just having a practical conversation, one where actually you're upping your own negotiation leverage, as opposed to looking at it from the perspective of, well, okay, I'm just going to sue you for that because I've got a breach of contract. And you know, Alex and I, as we both said, we're litigators, so we're naturally inclined to try and find a way and fight about it, perhaps, and go to court. But we're the fighters are urging you at this point to figure out whether or not there's a different way to solve the problem, because that might be faster, more cost effective, and hopefully actually enable you to keep your business going, as opposed to becoming embroiled in a long, protracted dispute. So those are just some general comments maybe on contracts that I can offer at this point. Happy to take any questions, Carrie Lee or Dawn.
Miranda, thank you. I love the upping your negotiation leverage. You know, that's the situation so many people are in right now, and just understanding. I love your terms, dusting off those contracts and pinpointing where people can be looking for this information, to get us started and feel more comfortable about what they can or what is in those contracts and what they can or how they can leverage negotiation. Carrie Lee, do you have some questions coming in?
Yes, I've got this. So I'm going to filter through. We're going back to leasing mostly again. So one is asking, I was supposed to move out at the beginning of April, but I couldn't since the movers canceled. I just moved out, so I was delayed 10 days. Can the landlord keep my full month of security deposit? And again, that's probably going back to that negotiation, but I'll let you take that, Alex.
That's something that may be set out in the lease about if the tenant has overstayed their welcome. And so I would look first to the lease provision to see whether, generally leases anticipate that, whether the tenant has stayed past, and then provides for a mechanism for how that will be sorted out, whether there are additional payments and how that works. If you haven't heard anything from the landlord yet, I would first check the lease, read through it. And if you've moved out now and you don't hear anything from the landlord, I mean, certainty is something that is extremely beneficial and hard to come by these days. And so it might be worth just reaching out to the landlord to confirm that everything is done, there are no further rights and obligations, and it was great to be there while it was, and just to confirm that there's nothing else outstanding on your part.
In writing.
Writing, yes.
That's right. And another question is, with yesterday's news about the rental support for business or commercial landlords, can you suggest a way for the renter to suggest that their landlord begin to look at that option? So somebody wants to be proactive and tell the landlord, there's this program, go get it to help me.
Yeah, I can't tell how it's going to be how it's going to unfold, whether the support is for the tenant, it goes to the tenant, or directly to the landlord, and whether both parties need to apply for something, or which party is supposed to be the one triggering that. So I wish we had more details, but I think it is an excellent suggestion that if your landlord isn't aware of it, or if you're the landlord and your tenant is aware of it, that you have a discussion about it and say, this has been announced, we don't know the details, let's keep each other informed about the details, because it's hope that there won't be any non-payment issues and that everybody can keep things going business as usual. And suggest a way, I mean, email, however you communicate with the landlord. And again, if you want to keep the record going for if you anticipate there may be future issues, email.
Great. And I think that goes back to, Dawn, some of our previous sessions where we reiterate to everybody, communication is key during this situation, whether it's in regards to contract, leases, suppliers, all of that, making sure you keep those communication lines open for sure.
Absolutely.
Yes,
Yeah.
yes.
And I have another question here. I have an upcoming lease, starts in May, on May 1st for 3 years. Is there a chance I can negotiate to postpone that? So not really something you would think about when you're, moving into a new space that you potentially would want to delay. So I don't know if there's any suggestions you can offer there.
Absolutely. It depends. So the term may start in May, but you may already be in the lease agreement may already be effective. So that's something that you want to check. Or whether the parties are saying we're not going to hit go. There are no contractual relationships starting until May 1. In either case, it's worth a conversation. Again, keeping the communication lines open, because it may be in both parties' interest to have that contractual arrangement be postponed or be altered in some way. And so, yes, I encourage you to reach out to the other party to see if that's a possibility. And if so, negotiate something that works for both of you and get it in writing.
Okay, great. And then I do have one question. We haven't touched much on it today, but about insurance. And this one is kind of event specific, but I also had a thought about, in lease agreements, in contract agreements, sometimes there is a clause about minimum insurance coverage and who's named on the insurance. So I'll plant that seed with you now. And then also just ask this question that was submitted to us. We put on fireworks shows for events like Canada Day, Halloween, etc. We prepay for a year of insurance, which is coming up for renewal in May, and we're unsure of future shows and past clients are unsure, as the event world has basically come to a halt right now. So, do we continue to prepay? We're a small company, and prepaying would keep the good relations with the insurance company. We're just not sure what we should do. Any suggestions welcome.
Sure, I can jump in with this, and Miranda, you can do cleanup after if I miss anything. I mean, this is a conversation in terms of whether you want this specific factual situation, whether to obtain insurance or not, renew your insurance or not, is really a conversation to have with your insurance broker. And there may be alternatives instead of getting a year-long, entering into a year-long contract for insurance, to see if you can get something on a shorter term basis or a temporary agreement in place while for insurance while you are uncertain of what your business future holds for the short term. So that's something that I would encourage you to have that conversation, see if there are alternative arrangements that you can enter into. And hopefully there will be some flexibility in that regard. In terms of the covenant to insure, that's usually referred to as a covenant to insure in your contracts with clients, about who's supposed to be getting insurance and who promises that they will get insurance. Yes, that's a common provision. And if you are obliged in your contracts with clients to hold insurance, then that is something that you should make sure that you do. And if it's something that you can't do and you can't satisfy that obligation, or you don't want to, or you want to change it, again, that's just another type of amendment or a change to your underlying agreement with your client. And so have a conversation with them about whether they're prepared to change that provision in some way, so that to release you from the obligation, say to hold very expensive insurance for a year long or something like that. So you've got two different relationships, your client relationship and then your insurance relationship with your insurer through your broker, that you have to manage here.
I agree with Alex. Talk to your broker, because I suspect a lot of people are trying to defer their insurance payments right now, and it's in some ways it's a mathematical thing, whether perhaps maintaining your policy will in the long run be cheaper than just halting everything right now and then buying a whole new policy again later and losing the claims history and that kind of thing. So your broker will be the best position to give you some advice on what might be the most economical. But other than that, definitely make sure, to the extent you have any existing contracts, as Alex has said, with clients who oblige you to maintain insurance, that you are doing that, or otherwise advising them that in the meantime you're you're not doing that until you have confirmation that the events are indeed moving forward.
Great. And I have a follow-up question. The person that was asking about moving out 10 days later has asked, I have an unconditional offer to lease from the commercial realtor, but his president has not signed the finalized lease contract. Is that okay? And I don't know if that's enough detail. I'll give that to you, Alex.
Yeah, if there's an offer to lease, but it's not signed, that it generally, it's probably not effective yet until the parties have signed it. And so if, and you're just, there hasn't been any agreement, you're just in the offer stage, and you may still be in the negotiations stage. So in terms of, is that okay? What I gather you're asking is that effective? Does that mean we have a contract? Probably not, but you might. So I would make sure that you have that question figured out, whether by just asking them to sign it and give it back to you. That way you have full certainty, or asking them to confirm that you have an agreement in an email or some other way, so that everybody knows what your rights and obligations are.
Okay, great. And Dawn, I'll pass it on to you to wrap everything up. We've only got about 3 or 4 minutes here.
Okay. Thank you, Carrie, and thank you everyone for all of the questions this morning, especially our thanks to Miranda and Alex. You know, you've taken a lot of information and expertise and just shared it in some very practical layman's language. So thank you for doing that. I love the term frustration of contract. That's maybe that's our term for the day. But for all of our participants today, you know, these are your opportunities to learn to, again, to manage what it is that you can control. Take control of what it is that you can control right now. Look for assistance. Check out Women's Enterprise Center, our website. You're going to get some great information from McCarthy Tetrault at the end of today's session as well. In an email, a link to programs and information. You'll get Miranda and Alex's bios, and just some good links that can help you. We also want to know, what else do you need? What information or supports would be most helpful for you at this time? We've got some upcoming webinars. We've got information on our website, and we're trying to keep it fresh and current and keep you in the know. They say it's what you don't know that causes your lack of sleep. So if you're not sleeping, it's sometimes fear of what it is that you don't know. So grab hold of what it is that you can learn. We've got upcoming webinars on grants for business, SEO for beginners, bloggers, some ways of maybe innovating in your business using some of these tools. And so stay tuned. Our sincere thanks again, Miranda Lam and Alex Koch. Thank you so much for being a part of our webinar today. Thanks, everyone.
Thanks, everyone. Bye.